look at subsection B. This is the waiver and transfer provision, all right? This is the provision that deals with juveniles who are going to be held and prosecuted in criminal court, subsection B. Not later than 3 years after the date of enactment of the Juvenile Justice Reform Act, unless a court finds, after a hearing and in writing, that it's in the best interest of justice, juveniles waiting trial or other legal process who are treated as adults. If you look at that section, it talks about, there's lots of qualifying language in there, in the interest of justice, has to be after a hearing and in writing and all of that. Not too worried about all of that. The part of the language I think that might be troubling some of you is that they shall not have sight or sound contact with adult inmates, and except as provided in subsection 13, they can't be held in any adult jail or lockup for adults, right? And then there's a whole list in subsection little I there about what the court has to consider to determine whether or not it's in the best interest of a juvenile or best interest of justice to hold them. And it's essentially just all the same language that courts have to consider when they look at the regular transfer decision, whether or not it's appropriate for the juvenile to be prosecuted in adult or juvenile court. And it talks about, when you follow it on down here, Roman numeral I and Roman numeral I guess, Roman numeral 2 down there at the bottom. The hearing has to happen every 30 days, and it can't be extended for more than 180 days unless the court determines there is good cause. Now, what of course is not defined in the Act is what's in the best interest of justice and what is good cause shown, right? There's nothing in the Act that gives us any guidance as to what is good cause shown. And failing such a definition, I think there are opportunities here for us to define or provide some guidance as to what good cause shown is, so that a kid that is held in an adult facility after being certified as an adult can continue to stay in that facility longer than 180 days. And I'm thinking that that is pretty much going to track the speedy trial provisions. Are y'all familiar with that, right? If the court makes a determination that a defense motion, or sometimes even a state motion, but the case should be continued for good cause shown, and that amount of time is charged to the defendant, or it's excluded for speedy trial purposes, that's going to be good cause shown to extend this 180 days. Do you see what I'm saying? So if there's good cause in the record somewhere, hopefully it'll be in a file with the juvenile in the jail, that if there's an extension granted by the court because the child needs, or the juvenile has been sent for a mental evaluation, or they want time to investigate mitigating circumstances and all of those things, all the typical motions filed by defense in these serious cases, that period of time is extended by the same period of time that would be extended for speedy trial. That's kind of how we're looking to implement that. What do you think? Well, there you go. It sounded friendly. Does anybody have any thoughts about that? I know this waiver and transfer piece has kind of been making people nervous, or it seems like it has anyway. What do you think about including a definition or something that ties this for good cause shown to the speedy trial language? Those seem to be related, or they seem like that seems like a good standard to exercise discretion here, because it's all related to holding the kid in a facility. Do you have thoughts about that?
Well, I'm from Delaware. I think that that on the surface is a good idea, but what may be a better idea is for you to send a charge back to each SAG and let each SAG send a formal letter to the judiciary of that state to find out what those judges would deem to be a reasonable cause, right? Because it's going to look different in different places. Speedy trial in Delaware might not look like the speedy trial statute in Wisconsin. So, so another question I'd have, not to sneak this in here, right, because that's my answer to your direct question, but my question is, for those states that charge a juvenile as an adult, a lot of those states, including my state, view that juvenile from that time, once they've gone through the proper hearings to be deemed an adult, to be an adult.
And your state is free to do that. The question becomes how, if you're taking Title II money, how do we deal with that if Title II doesn't necessarily allow that? And so what I want you also to look at is back here in the definition section of adult inmate. This is back in section 103, number 26. The definition is there in number 26. The term adult inmate means an individual who has reached the age of full criminal responsibility under the applicable state law and has been arrested and is in custody or allowing to address a criminal charge. He's been convicted of it and he's simply waiting placement at the prison, right? That's an adult inmate. But it excludes, look at subsection B, it does not include, it specifically excludes those individuals who at the time of the offense were younger than the maximum age at which youth can be held in a juvenile facility under applicable state law. That reaches to this question of extended juvenile jurisdiction, right? I mean, most of your states have like up till 18, but then they can be held up to 21 or something like that, depending on your state. The maximum age at which a juvenile can be held in a facility, and this offense was committed, or at the time of the offense, he was committed to the care, custody, supervision, post-placement, on parole from a juvenile correctional agency, or somehow under the control or operation of the juvenile court, right? So it's that extended juvenile jurisdiction population. So now we have, for this notion of an adult inmate, we have, it's not kids. I don't want to use the term real juveniles. I know I'm trying not to be offensive here, but kids we typically think of as kids, right? Under 18, or whatever the age of criminal responsibility is in your state. For some of you it's 16, for some of you it's 17. So it's juveniles, right? We know it's not them. It's definitely, they aren't adult inmates, so they're excluded. But let's assume your extended juvenile jurisdiction age is 18 to 21. Let's assume that. Well, those are no longer adult inmates. You understand? In the Act, these are not adult inmates. If, and here's the big if they committed their new offense while they were still under the control of the juvenile justice system in that extended juvenile jurisdiction capacity. Are you with me? See, it's not so confusing. Okay. So we know juveniles aren't adult inmates, hallelujah. The 18 to 21-year-old set, or that little subset of adults, actual adults, are not adult inmates if they committed their offense while they were under some type of extended juvenile court control. But in terms of violations then of what's happening in your jail, can these kids, these 18 to 21-year-olds, they can actually be held with adult inmates. And why would that be? Can you see? Because they don't fit the they are not juveniles, right? They're not juveniles and they're not adults. They're that crazy group in the middle. And because they don't, the code, the act, does not define what a juvenile offender is. That leaves it to you. It leaves it to each state to define what a juvenile is. You'd think it'd be nice they could define juvenile, but they didn't. It's to each of you, so we have 56 different definitions of juvenile. And they're not juveniles. They're not actually adults. There's this group in the middle that can be adults, that can be housed with adults, because the prohibition is in the act is that you can't hold juveniles with adult inmates. Do you see? I'm going to have to say that a lot, aren't I? Yeah, I know. Yeah, you know what we're going to have is a mind map, right? One of those things where if this, then this, if yes, no, then this, and then no, yes, then down here and around. That's what you're going to need. Juveniles are defined the way juveniles are defined in your state. If you have someone who has reached the age of criminal responsibility but did it while he was still under extended juvenile jurisdiction control of some sort, and he committed a crime, he is not considered an adult inmate under the Act, which means juveniles can be housed with them, right? They can all be in the same cell. It means these can also be held with actual adult inmates because the Act prohibits juveniles from being with adults, not this group, right? So this group can be held with adult inmates because they don't meet the definition of juvenile as the Act defines, even though they are not, in fact, adult inmates. It's insane. I get that. I didn't write this. I wouldn't write this. Is this only water? Okay. Okay. You're going to, you just think you want to know how to implement this act. You don't really want to know. Okay. Believe it or not, this is good news for you. That's the bottom line. Oh, wait, we have a question. Yes,
I
sir.
do. So Administrator Harp, and this, I think actually this was previous guidance issued by Administrator Flores back in the day. But if we have, so Wyoming has the age of extended criminal jurisdiction is to the age of 20.
It's a little garbled.
To the age of 20.
Okay.
So if we have somebody who's under the jurisdiction of juvenile court, say age 19 in a facility, they commit a new offense because they've reached the age of majority.
Correct.
So does the fact that they commit a new offense, even though they're in a juvenile facility at that point, does that turn them into an adult?
Okay. Those are two separate issues. Isn't that great? There's two separate issues there. You have the question of, can they be prosecuted as an adult, right? There's that adult defendant consideration, but then there's also the inmate, or how you can hold them, that
Yes.
consideration, okay? Those are two different things, and we can't really conflate those here. You have the classic 19-year-old who's in a juvenile facility on an extended thing, he beats up a guard, now what are we gonna do with him? Do you have to move him out of that facility? The answer is, no, you don't. But if you charge him as an adult,
Right.
like a regular, because original jurisdiction for that offense would put him over in criminal court, right?
So if I'm understanding, and that makes sense. So I think what I'm understanding is, so like if he assaults the guard and they treat it as, I don't know, probation revocation or something in juvenile court, then he would remain a juvenile for purposes of monitoring. But if they charged him, say, in circuit or district court for the new offense, at that point, he would become an adult and would have to be sight and sound separated?
No. He would become an adult in terms of for charging purposes, right? The law would allow him to be that first person, right, under the Act. Look at 26, an individual who has reached the age of full criminal responsibility and has been arrested or awaiting trial on a new charge, a new criminal charge, but doesn't include those kids at the time of the offense. They were still younger than the age of maximum responsibility, and they committed the offense at the time that they were.
Right.
But it doesn't have to do with the charge they face. It has to do with how they are housed. It has to do with whether or not that's a violation of the sight and sound separation issue. It doesn't have to do with how they can be charged. There's adult inmate, and then there's adult for purposes of criminal prosecution.
I guess where I'm still confused, though, because it says does not include a juvenile who, at the time of the offense.
Right.
So originally, when the kid was 19, he committed the crime when she was 16 or 17 or whatever.
Correct.
So that's clear.
Right.
But at the time of the offense, if they're 19, then they were not younger than the maximum age. Well, I guess, yeah, I guess they are. Okay.
They are. See?
Okay.
That decision tree is looking pretty good right about now. We really are going to have to come up with that, I think.
Okay.
It's a little crazy, I know, but you kind of have to separate out the idea that you can have an adult inmate, or what fits the definition of an adult inmate doesn't necessarily any longer comport with who is a legal adult, who is over the age of majority. That doesn't determine sight and sound separation issues any longer as a result of this definition. This is what we've been spending our year doing. I don't know what y'all been doing. No, all right. Okay, so that's the definition of an adult inmate. That will take some time to discuss. I want you thinking, though, please, 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 think and continue to ask these great questions, because what we're going to have to do, your sheets are on the table, because what I want to do is I want to get hypos from you all and say, yeah, well, what about this? You know, we got this crazy kid who did this. Where does that fit in this? And we want to just roll through all of them between now and Thursday and see if we have something workable for how we're going to look at this. But you all are going to be the ones that have to tell us. And you all have the big brains anyway, and you're the ones out there working. If you can think of something better in terms of how we implement this than what we've come up with, I am all ears. All right, now let's go back to waiver and transfer. It uses the term This is actually an example of your question. It says, treated as adults for purposes of prosecution. See how it makes the distinction there between they're treated as an adult for the purposes of prosecution versus who's in the jail and who's going to live where, who gets to stay in whose cell. That inmate distinction and the jurisdictional court authority to prosecute as an adult thing are different now. Let's see. See, and in waiver and transfer, if you look at waiver and transfer, it says those who are treated as adults, juveniles, as juvenile is defined in your state, juveniles treated as adults for purposes of prosecution in criminal court and housed in a secure facility shall not have sight or sound contact with adult inmates. Okay? They can't have contact with adult inmates. Can they have contact with other juveniles that are being prosecuted as adults? Yes. Can they have contact with 18 to 21-year-olds who are in that kind of swing group that could be either way? Yes. It wouldn't violate anything because 18-year-olds aren't adult inmates. This group that committed their offense while they were in the facility under juvenile jurisdiction aren't adult inmates. So the good news is there's actually, although it reads in a very complicated way and you really kind of have to think it through, I think the number of times there's going to be violations really is reduced. There's not going to be that many problems because this group of kids, the kids that are in that special category of extended juvenile jurisdiction kids that actually commit an offense while they're on EJJ, the number of those per jurisdiction are pretty small in the course of a year. I've actually talked to Mike Dempsey at CJCA to see if he can help me gather some of those numbers so we get a sense of how many people, how many facilities this could actually implicate. But it's actually going to be fairly small. And juveniles can have contact with them, and they can have contact with adults. Juveniles can have contact with them because they're not adult inmates, and they can have contact with adult inmates because they aren't juveniles. You with me? Yes.
I'm Christy Love from DC. I'm gonna put the question out there. So we have a situation for our transferred and waived juveniles who are now being treated as adults. I think our question is, what happens when they turn 18 and they are now convicted? Can they be housed with adult inmates?
They start out as juveniles who are transferred to adult court, but they were juveniles at the time they offended?
Yes, so they were under 18 at the time of the offense.
Were they under juvenile court?
No, they were never under juvenile court jurisdiction because we do mostly direct file.
All right, so then they're just a juvenile. They're just your basic juvenile who's committed a crime. The state's treating them as adults, right?
Yes.
Okay. So now the question becomes, who can they have contact with?
Mm-hmm.
They can continue to have contact with anybody in this category, right? If you have any of those, which I think is few or far between, but they still have to be sight and sound separated from actual adult inmates. Okay, the fact that they're treated as an adult for purposes of prosecution, it doesn't change anything, right? We have those issues are separate. How we're going to treat them for prosecution, who we're going to let them be housed with. Two different things. Okay? So go ahead with the rest of your
That's understood prior to when they turn 18. So now my question is, when that person turns 18, can they be housed with adult inmates?
My money is yes. My money's going on yes, because they don't fit this special category of, well, they can be housed with them anyway. Yeah, I think they absolutely can.
Yes.
I think they can, because they would then fit the first section of that definition. That's where I'm putting my money. Tom, you look confused. Are you confused? Dazed? Disinterested? I'm sorry. Okay, go ahead.
So if I look at the term of adult inmate,
Do what now?
if I look at the term adult inmate
Yes.
and not the lower subsection of the rule,
Wait, subsection what now?
and not the lower subsection that you're looking at, so it says an individual,
An individual.
which could be an adult or a juvenile, right?
Well, no, an individual who has reached the age of full criminal responsibility.
Correct, but the second subsection says, I'm old, so I can put my glasses down, has been arrested
Right,
and is in custody or awaiting trial on a criminal charge,
correct.
or is convicted of a criminal charge or
Correct.
offense, which to
Right.
me, individual means it could mean a juvenile who has been convicted,
Okay,
right? And then therefore, the case in which they're talking about is a kid who's direct foul under the age of 18, who now meets adult because they're over the age of 18, and therefore sight and sound, as you describe it, wouldn't apply because they meet this subsection under 2 of adult inmate.
okay. I think that's great. I think you can absolutely read that way. I think that's what we just said, right?
No, I think you said that if they were between 18 and 21, committed the crime before their 18th birthday, that they could not have contact with adult inmates, unless I misunderstood what you were saying.
I think so, because once they turn 18, then it doesn't matter if they're a juvenile who commits an offense, right, whatever. Say they're 17, 16 years old, they commit offense, prosecutors charge them, or they have been waived into criminal court.
Correct, right.
Then while they're in jail, they age out. While they're waiting trial, or
Right.
maybe while they're waiting for a bed at the prison, or whatever the deal is, while
Right.
they age out, they
Correct.
age in over the age of majority, yeah, then they can go with adult
Right,
inmates.
sight and sound does not apply. Okay,
Right.
then we're on the same page, thank you.
I think we're on the same page. Yes? Hi, Sabrina.
What if they fall in that bubble group because they weren't 18 at the time, but they're in custody, they turn 18, can they be moved back into the juvenile facility?
Okay, this is where it gets to, when they committed this new offense for which they are somehow find themselves newly incarcerated, or they committed the new offense, were they under juvenile court jurisdiction when they did that? Say, for example, you have a 16-year-old who commits an offense, and he goes to a lockup. This is bad news. This usually means I've done something wrong when they start coming close like this, trying to throw a net over me without you noticing. If you have a 16-year-old who commits whatever offense, and he gets himself incarcerated in a juvenile facility, and he then turns 18, right, or 19, and commits a new offense, beats up a guard, does whatever, the question then is, where does he go? Can he stay in the juvenile facility? And the answer is yes, if there isn't a new, actually, didn't we decide he could stay in the facility? He can stay in the facility. It's, yeah, hold on. Turn it on.
Okay, so I just wanted to say, you guys are raising some really, really good questions and some really, really complicated questions. And I think I'm a little worried that we're going to run out of time to do our focus group discussions. We really wanted to get your feedback on these new provisions in the Act and some of the good cause shown things that Caren was talking about earlier, and just in general, what your concerns are about these new provisions. So what I'm going to urge you to do right now is write those questions down, because it's really, really difficult when you guys are asking us about these super complicated situations for us to make sure that we are answering them correctly. So if you guys can write those questions down, if you look at your agenda, we have a whole session on Thursday that's going to be devoted to FAQs. We will bring those written questions with us back to our hotel rooms and study them and make sure that we're answering them correctly. We will answer them for you on Thursday. But I think right now, if we don't move on to the focus groups, we're going to run out of time.